Good morning and welcome back. The lecture today will focus on the protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa, also known as the Maputo Protocol. It is my pleasure to introduce our distinguished speaker for this topic, the Honorable Janet Ramatoulie Sallah-Njie, Member and Vice President of the African Commission on Human and People's Rights, the Special Rapporteur on the Rights of Women in Africa, the Chairperson of the Committee on the Protection of the Rights of Peoples Living with HIV and those at risk, vulnerable to, and affected by HIV, and the Vice Chairperson of the Resolutions Committee. She served as Chief Parliamentary Counsel, Solicitor General, and Legal Secretary, and participated in drafting laws relating to women, gender, and development in the Gambia. She is the former chairperson of the Institute for Human Rights and Development in Africa, the founder and first president of the Female Lawyers Association in Gambia, and a lecturer in legislative drafting at the Gambia Law School. She has just finished a session of the African Commission on Human and People's Rights. She needs a few minutes before joining us. So I am going to take this opportunity to express my sincere appreciation to her for her efforts to obtain some of the first signatures for the convention that was discussed by Hajir Geldish on Monday. And that is the new African Convention to End Violence against Women and Girls. And since we do have a couple of minutes before she joins us, I'm going to share with you the statement that she made on the adoption of that historic landmark convention. Following the adoption of the convention, she noticed that it reaffirmed, begin quote, Africa's commitment to eliminating all forms of violence that have long been silenced, oppressed, and harmed women and girls across the continent. It builds upon and elaborates state responsibility for the implementation of Articles 2, 3, 4, 5, 26, and other relevant articles of the Maputo Protocol. It is a testament to the power of unity, advocacy, and the unwavering pursuit of justice. Now we must advocate for its ratification to ensure its speedy entry into force and promote its full implementation, translating these commitments into tangible protections, support systems, and legal frameworks that safeguard the rights and well-being of every woman and girl. Together, we move forward toward a future where no woman or girl lives in fear, but rather in freedom, dignity, and equality. Thank you for joining us today when you are so busy with the current session of the African Commission. You actually gave me enough time to read your wonderful statement on the convention that Hajir Geldish addressed on Monday, and that is the historic African Convention on Ending Violence Against Women and Girls. So, Madam Commissioner, the floor is yours.
Thank you very much. It is really my honor, my pleasure, and my privilege to be taking part in this very important lecture series and to contribute my insights and perspective regarding the ratification, the adoption, ratification, and the innovative provisions in the Maputo Protocol, which is the focus of my lecture today. So as I indicated, my lecture today will focus on the protocol to the African Charter on Human and People's Rights, on the rights of women in Africa, affectionately and commonly referred to as the Maputo Protocol, because it was adopted in the beautiful city of Maputo. And that's why it's known as the Maputo Protocol. In terms of the outline, just to give you the outline of what we're going to do today for this lecture, I will start with an introduction to the Maputo Protocol, just the background, the context, and why it was adopted and how it was adopted, the entire journey of the protocol on the rights of women in Africa, that we celebrate today as the Bill of Rights for Women within the continent as being very innovative. Talking about it being very innovative, then we will move on to the innovations of the Maputo Protocol. What is different in the Maputo Protocol? Because it's not the first instrument. There are other instruments. You have the charter, which is the parent instrument that established the commission. I'll talk about the commission also. And then we have the CEDAW and other relevant information instruments. CEDAW is a global instrument that applies to the globe, the world at large, those who ratified it. But the Maputo Protocol is actually unique in the sense that it applies to the African continent and speaks to the unique context of African women and their lived realities. And what are these innovations? What is different? Then we'll move on to implementation and monitoring. Who has the responsibility for implementation and monitoring of the protocol? And this is where we also go in detail into the African Commission and how we work, our different mechanisms, and how we organize ourselves to carry out our work, and through the mechanisms and the working groups. And that we will zero in on the mechanism responsible for the monitoring the implementation of the Maputo Protocol at the national level, which is the mechanism of the Special Rapporteur on the Rights of Women. So I'll give you a general overview of the mechanism of the Special Rapporteur on the Rights of Women, its role, and on what it does, and how it was established, and how significant the mechanism has been with regard to the conceptualization of the protocol, the adoption of the protocol, ratification processes, and where we are today. And that will lead us to the soft laws that we've actually developed emanating from the protocol. And the protocol will always have the state responsibility, the hard law, and I highlight what state responsibility is. But as the mechanism also, we actually amplify on those provisions by developing general comments, guidelines, and resolutions. And we'll take you through some of those very important instruments that we've developed, knowledge products and amplification products. And then we'll move on to challenges and gaps, because I think whatever you do, you're bound to have your challenges, bound to have your gaps, and then we see how, together. And I'm sure when we identify the challenges and the gaps, maybe questions will come up, and then, generally the recommendations we make with regard to universal ratification, because it's one of the instruments that have ratified broadly, with so many member states being members of the part of the Maputo Protocol, but we're looking for universal ratification. So we always continue our journey and always continue our promotion missions that we embark upon to ensure universal ratification. But of course, ratification is not enough, because you have to also make sure that the law is domesticated at the national level, implemented effectively. And this is where we do make recommendations for going forward. So we just now quickly take you to the introduction to the Maputo Protocol, quickly here. So in terms of the Maputo Protocol to the African Charter on the Rights of Women in Africa, you're seeing the beautiful photo of this beautiful woman representing the continent. Yeah. I think it may be pertinent to note that how did it come about, the historical background and the context, what led to the adoption of the Maputo Protocol. It may be pertinent to note that in March 1995, a seminar was organized by the African Commission on Human and People's Rights and WILDAF in Lomé, Togo. And this is where the idea of a regional women's rights instrument was being mooted and discussed with the women's rights movement within the continent. So this seminar was a joint collaboration. You must know that the African Commission were responsible for the promotion and protection of human rights within the continent. And in carrying out our mandate for the promotion of human rights, we carry out sensitization seminars, we carry out workshops, carry out studies. So this was one such activity and initiative that was carried out as far back as 1995 in Lomé, Togo, together with one of our partners, WILDAF, Women in Law and Development in Africa, that continues to be a very valued partner of the African Commission, and in particular, the mechanism of the Special Rapporteur on the Rights of Women in Africa. I'm sure I've already been introduced that I'm the vice chairperson of the commission. I wasn't here. I had some other committees I was juggling with, the vice chair of the commission, but in particular, I handled the mechanism of the Special Rapporteur on the Rights of Women in Africa. But we'll get to the mechanism in details as we proceed with this lecture. So in Togo, two different standpoints were represented. One argued for an addition to the African Charter, that is a separate treaty, different from the Charter, meaning that we had a Charter on its side dealing with human rights generally, and then we have another instrument, it's a separate, completely separate and distinct treaty dealing with women's rights. But then we have to recognize that women's rights are part of human rights. So that was one argument, and then the proponents were saying, no, we cannot have that, because the Charter itself makes provision and makes room for supplementary instruments to be actually issued under the umbrella of the Charter. So one that I argued for the utilization of the existing provisions of the African Charter to protect women's rights, meaning that we center the women's rights within the context of the Charter, but building on what you have in the Charter and having a separate instrument. So these two arguments were mooted extensively during the deliberations in Togo in 1995, as far back as 1995. But why do we need to have a separate charter or a separate instrument? Because there was an argument also that we may not need to have a separate instrument because we already have provisions in the African Charter dealing with women's rights, dealing with protection from this elimination of discrimination. So proponents will have argued that, but why do you need a separate instrument? We already have an article in the Charter. But the African Charter provision, that's what we have in Article 18 of the Charter, situates the issue of women's rights within the family and recognizes that the family shall be the natural unit and base of society. This is the provision, that is what is provided in the provision. It shall be protected by the state, which shall take care of its physical health and moral, that the state shall have the duty to assist the family, which is the custodian of morals and traditional values recognized by the community. And then in subparagraph 2, subsection 3 of Article 18, it says the state shall ensure the elimination of every discrimination against women and also ensure the protection of the rights of women and the child as stipulated in international declarations and conventions. So you can see that this provision actually did not have separate provisions relating to women, extensive, comprehensive provisions relating to women, but situated within the context of the family, and moreover, refers to international declarations and conventions, meaning that for you to be able to deal with the issues relating to protection of women's rights within the continent, you wouldn't only have to make reference to the Charter, you will also be mindful of what is provided for international declarations. At the beginning, I mentioned the Sallah-Njie Convention. So you may need to have recourse to those. So it was not very as comprehensive as we wanted it to be. And then you have subsection 4 that talked about the age and the disabled shall also have the right to special measures of protection in keeping with physical or moral needs. So this is, in essence, this is what the African Charter on Human and People's Rights we had with regard to the family, the women's rights. And then you understand the context why there were arguments for and against having a separate instrument, an argument relating to how do we ensure that we actually, beyond what we have in the Charter, situating women's rights within the context of the family, what do we do to make sure that we have an instrument? So why an additional treaty? Why is it important for us to have an additional instrument, bearing in mind, like I said, the previous declarations, bearing in mind Article 18 of the Charter? It is very clear that from what I read, that the reference to women in the Charter exclusive is in relation to the family. And this could be seen as entrenching a view of women as valuable only with relation to their reproductive and caregiving roles. And certainly nobody wants to entrench and perpetuate that kind of belief. And in fact, this is why some of the conservative beliefs we have today are trying to roll us back to saying that this is what a woman should be, but we didn't want to perpetuate that. And also within the context of the Charter, we realize that introducing the racism within the context of the family remains the chief source of discrimination against women, perpetuates traditional cultural values that place women and children under the authority of the male household head, like I said. So if you only deal with women's rights within the context of the family, certainly we will have challenges, because within the African continent, of course, the cultures are not homogeneous. We have different cultural contexts in different settings, but overall, the cultural settings we have within the continent actually perpetuate the issue of discrimination against women with regard to traditional values, sometimes religious values, and places women and children under the authority of the male household. So it was found necessary that it would have been necessary to have a separate instrument which actually separately deals with women and women's rights issues without linking it or situating them within the context of the family. Also, the provision in the charter lack reference to specific harm suffered by women, because you cannot deal with women's rights issues without dealing with the specific harms that women actually find themselves subjected to within the continent. And these are issues like female genital mutilation, which is prevalent in the continent, forced marriages, inequality in inheritance of widows and female heirs. So these are some of the things that one would expect to find in an instrument that is dealing with women's rights. But unfortunately, what we have in the charter, although it's a first step in the right direction, but it didn't go far enough. So there was a need to have something that is dedicated to dealing with the rights of women, the intersectionalities of the rights relating to all the violations and discriminations that women experience within the continent. So these are some of the things that given the rationale for why we needed to have a separate instrument. So after the conceptualization of the seminar in 1995, from 8 to 9 March, the African Commission, together with the civil society organizations that came together, actually prepared a resolution for consideration by the heads of states. So at the time, it was not the African Union, it was the OAU, Assembly of Heads of States and Government. And unfortunately, they affirmed the need to have an additional protocol to the African Charter at the 31st Ordinary Session July 1995. So at least the approach that was adopted was an additional protocol to the charter, as opposed to having a separate and distinct charter that stands side by side with the African Charter. If you know that, if you look at the African Charter, the charter itself makes it possible. A relevant article of the charter provides for supplementary protocol to be issued to supplement the information that is provided for in the charter. So after the adoption and affirmation by the heads of state, in 1997, an expert meeting was held to prepare a draft protocol to the African Charter on Human and People's Rights concerning the rights of women in Nouakchott. So conceptualized in 1995 March, 1995 in July, the heads of states adopted and affirmed the whole idea of having an additional protocol. In 1997, expert meeting was convened for the drafting of the charter, and the first draft was prepared in 1997. In Kigali, 1999, the draft protocol to the African Charter on Women's Rights was also considered during the 26th Ordinary Session of the African Commission on Human and People's Rights from the 1st to 15th November to review the first draft. And this is where the second draft was generated. So you consider the process of development of this charter came from bottom up, not from the top, but from bottom up. Women of the continent came together, had a discussion, had a dialogue, and recognized the need to have an instrument that is comprehensive, integrated, recognizes the intersectionality of rights of women, recognizing the unique status of African women, recognizing the lived realities of African women. And then from there, it moved on to the main policy organs. That is normally it will be the Executive Council and then thereafter to get to the heads of states. And that was a total buy-in there. And it followed a very comprehensive process. In Nouakchott, the experts came together, and of course, when experts meet, all stakeholders will be represented there. In Kigali, the commission itself deliberated on it, reviewed the draft, and a second draft was generated. But it may be pertinent to note that whilst this, hold on, I need to just get this out of here. Whilst the charter was being championed, there was also another instrument that was actually being looked at by the Organization of African Unity. That is the OAU Convention on Harmful Practices, 2000. And this was a convention on the elimination of all forms of harmful practices affecting the fundamental rights of women and girls. And this was a parallel initiative, and it was felt that you cannot have two instruments relating to women's rights appearing side by side. So there was a need to harmonize and put together, to merge the second draft of the protocol with this initiative on OAU Convention on Harmful Practices, which was a draft at the point in time. So this is where an updated draft was actually developed, merging and ensuring that all the relevant concerns relating to women's rights will be incorporated in one instrument. So in 2000, the draft protocol to the African Charter on Human Rights and the Rights of Women in Africa, that's the final version of the, was actually produced, actually, like I said, merge the two instruments, and then you had the third draft of the protocol. Then in 2000, and this was 2000, in 2001, there was a report of the meeting of experts on the draft protocol to the African Charter on Human and People's Rights and Rights of Women was adopted in Addis Ababa, which proposals for amendments, and these amendments were all taken on board because, like I said, this was all part of the consultative process as we're dealing with the journey, the entire journey that this protocol took. I think what is really quite commendable in terms of the journey it took is to reinforce the fact that it took on board all stakeholder views, all relevant aspects of women's rights. So it didn't left no one behind in the whole process of the development of this instrument. But of course, as in line with the practice, you can't actually have an instrument that is generated, despite you have all experts coming on board, but then you will have to also ensure that the legal counsel at the African Union will also be given the opportunity to ensure harmonization, consistency, that there is nothing in the charter that runs contrary to the AU Constitutive Act, or at the time OAU. And the legal counsel made their comment in 2002, and amendments were incorporated, and also comments thereafter, comments by the NGO Forum. I think it may be interesting to know that African Commission is one of the main organs of the AU that works in close collaboration with civil society. During every public session that we have, it is always preceded by an NGO Forum. So the NGOs get the opportunity, stakeholders, the human rights community within the continent will always have the opportunity to deliberate on matters of importance to the continent related to human rights. So the NGO Forum itself was also given the opportunity. And once the NGO Forum concludes the meeting, the resolutions that emanate from the NGO Forum will normally feed into the resolutions that will eventually be adopted by the African Commission as we deliberate when we meet as commissioners. So the NGO Forum also had the opportunity to really review and deliberate on this in 2003. And comments were made, which were considered for inclusion by the meeting of experts. Then in Addis Ababa in 2003, you had the draft protocol to the African Charter on Human and People's Rights adopted by the ministers in Ethiopia on March 2003. That is the fourth draft. Then eventually, the Maputo protocol to the African Charter, then you have, it was adopted finally by the heads of states, because in terms of the way the AU works, it may interest you to know that after going through all the expert committees, you will also eventually have to go to the Executive Council made up of the ministers and ultimately the Assembly of the Heads of States, and instruments are finally adopted by the Assembly of the Heads of States. So after a whole process that started in 1995, with all the consultative processes, merging several instruments, ensuring that there is consistency, making sure that civil society takes part in it, making sure that member states also reflect their views and aspirations through the Executive Council. Eventually, the instrument, the Maputo Protocol, was adopted on the 11th of March, 11th of July, a very historic moment in the history of women's rights within the continent, 11th of July, and then entered into force on the 20th of November, 2005. Entry into force requires at least always 50 ratification. So by 20th November 2005, the 50 ratifications were obtained. And this is the journey in terms of background and context for the Maputo Protocol. Okay, I did mention that while the protocol was underway, the AU Women's Unit and Inter-African Committee was drafting a convention on harmful practices. So this is the two were merged, just to underscore the fact that if you look at the protocol itself, to avoid duplication, these two instruments were merged, and you look at the relevant articles of the protocol. I'm hoping that the participants have the articles of the protocol at hand, so that as I'm proceeding, they will be able to see and verify and confirm the information that is being provided for. So this slide just reminds us, adopted 8 years after the drafting began. Like I said, we started 1995 conceptualization, 11th of July 2023 by the African Union Assembly of Heads of States, entered into force 2 years, 4 months after it was adopted. And in comparison to other instruments that took more than 5 years to enter into force, at least the charter is actually recognized as one of the fastest to enter into force. It took more than 9 years for the African Charter, the rights and welfare of the child, to enter into force, and 5 years for the African Charter itself to enter into force. So it is quite commendable, just to highlight that it entered into force very, very fast. I think this also underscored the importance and the significance placed on women's rights within the continent, and recognition of the gross violation that women experience within the continent, and the fact that the heads of states at that level actually had the political will, which was quite commendable, to have an instrument dedicated to women's rights within the continent. So this is the journey and the background. So in terms of the status of ratification, just to give you an idea, as of July 2025, as of today, 45 member states of the AU have ratified the protocol. 10 AU member states have not ratified the Maputo Protocol. I think it's important to know who these member states are. We have Burundi, Central African Republic, Chad, Egypt, Eritrea, Madagascar, Morocco, Niger, Somalia, and Sudan. Out of these 10 member states, Burundi, Central African Republic, Chad, Eritrea, Madagascar, Niger, Somalia, and Sudan have signed the protocol, but have not ratified it. Of course, it is important to note that when you sign an instrument, according to the Vienna Convention on the Law of Treaties, you express a willingness not to do anything that contradicts the protocol, despite the fact that you have ratified it. So by signing it, that's the commitment that has been made by the states of Central African Republic, Chad, Eritrea, Madagascar, Niger, Somalia, and Sudan. However, it is disheartening to know that Egypt and Morocco have neither signed nor ratified the protocol, just so that you see in terms of the context where we are. And as the Special Rapporteur on the Rights of Women, together with stakeholders, we continue to work towards what we call the All for Maputo, for the universal ratification of the Maputo Protocol. I think just recently, about 2 weeks ago, there was a promotion mission in Central African Republic, and we've received a very firm promise that the instrument of ratification will be delivered very soon. We're engaging with Burundi also, and we're hoping that Burundi will soon come on board. And we continue to engage with all the other countries that are yet to ratify. Egypt and Morocco have not even signed, so we'll see what we can do. At least those of you who come from those backgrounds and contexts, you can see what you can do in terms of our engagement, because we always say that human rights is a collective responsibility. We all have a role to play in encouraging states to ratify, domesticate, and implement relevant instruments, especially an instrument as important as the Maputo Protocol. It is pertinent to know that, yes, whereas we have 45 ratification, several of these countries have actually entered reservation on very important relevant articles of the Maputo Protocol. In terms of the protocol itself doesn't have a reservation clause in the charter and the protocol. However, reservations were entered by Ethiopia, Kenya, Cameroon, Mauritius, Namibia, Rwanda, South Africa, the Gambia, Uganda, and Algeria. However, Rwanda and the Gambia, I think I missed Gambia there, Rwanda and the Gambia, we too have since withdrawn the reservations that have been entered under the protocol. And what are the articles that are actually reserved? I think it is important to know, because it's very important, because we say the protocol is very innovative, but it's rather unfortunate that sometimes the articles that are reserved are actually some of the innovative provision. One of the most common reserved articles are Article 42A, which is marital rape, because most countries don't recognize that a woman within a matrimonial union can be raped. Article 6 dealing with marriage, also their reservations have been entered. Article 7 deals with property rights of women, and these are also innovations where really when you reserve all these articles, you undermine actually the basis and the fundamental consideration that actually made it necessary to have a protocol. And then we have Article 14, sexual and reproductive health rights. Also, the protocol actually is lauded as one of the instruments that actually boldly and speak on issues related to sexual and reproductive health rights, but countries have entered reservation on this. And at the level of the African Commission, as we continue to advocate for universal ratification, one of the things that we also want to focus attention on, now that we have 45 ratification, which is near universal ratification, we're tracing our steps and going back, engaging with countries that have entered reservation to see how those reservations can be lifted. What kind of framework? What are the challenges? Why is it that states have not lifted their reservation since they ratified? Because when you enter a reservation, it doesn't mean that you should go to sleep and just say, I've ratified and this is a thing. You make a commitment that you're going to engage in awareness raising, education, and prepare the legal, institutional, policy framework and socio-cultural setting in terms of awareness raising, and progressively work towards lifting the reservations. But we've realized that apart from the two states, Rwanda and Gambia, that have lifted their reservations that they were initially entered, all other countries have not. So we want to engage on that also in terms of lifting of reservations. So what are the innovations of the Maputo Protocol? Because now, after giving the background, the context, countries that have the journey itself, countries that have ratified, countries that have not ratified, countries that have yet to sign, countries that enter reservation. Why is this instrument innovative? And why do we always talk about the Maputo Protocol? The Maputo Protocol, of course, as I said, does not stand on its own. It builds on existing protocol. If you look at the preamble to the protocol, it will reference to all the existing instruments. But what makes it innovative is the fact that it expressly mentions issues that you don't have and are glossed over in other instruments. It is the first binding African instrument to address HIV/AIDS. We've never had an instrument that dealt with HIV and AIDS. It dealt with issues related to medical abortion, polygamy, and domestic violence. These are very sensitive issues that touch on cultural values. And for the very first time, we have an instrument, a legally binding instrument that deals with issues. We all know the challenges with HIV/AIDS within the continent, especially as it deals with women's rights issues. So having a dedicated instrument on that was actually quite innovative. The issue of medical abortion also very sensitive issue, but for the very first time provided for polygamy within the African context and how it should be dealt with in terms of recognizing the rights of all people, all women, and ensuring that monogamy is the preferred option, but recognizing the fact that women in a polygamous relationship also should have their rights respected. The issue of domestic violence and its prevalence within the continent, this is the very first time we have an instrument, legally binding instrument dealing with domestic violence. It also provides a very comprehensive definition of discrimination, harmful practices, and violence against women. For the very first time, we have an instrument that does that. And we will deal with the issues of the definitions and what it says. I would just want you to just look at the definition section and see what all these definitions are and how comprehensive they are. And maybe if you have questions, you may ask. But most importantly, the protocol recognizes the intersectionality of rights and the protection of vulnerable groups, because they're recognizing the fact that you cannot just deal with one right without linking it to all the other rights that are relevant, because everything is linked and connected. So you cannot place premium on one and disregard the other. So it protects vulnerable groups, including refugees. For the first time, you have an instrument dealing with that, widows, women with disability, elderly women, and women in conflict. These are provisions that we didn't have before, very innovative, speaking to the unique and specific needs and requirements of African women and challenges that African women are confronted with. As you can see, these were things that were glossed over previously in policy statements, but now, for the very first time, we have a legally binding document that deals with that. Also, unlike the African Charter, because African Charter, if you look at the preamble to the African Charter, as I said, the protocol is one of the instruments, a subsidiary instrument under the Charter. The preamble to the Charter actually provides that as we deal with the rights provided for in the Charter, we must be cognizant of African values. But unlike the Charter, In the Maputo Protocol, it links African values to equality, dignity, justice, and democracy. I think this is very important. So it takes it further. It doesn't just mention African values, but actually links it to equality, dignity, justice, and democracy. It specifically addresses violence in the private sphere. I think this is very important and requires states to criminalize marital rape, like I mentioned. So this is quite interesting. So it's not just about violence that happens in the public domain that is dealt with. Domestic violence, violence in the private sphere also is provided for comprehensively in the Maputo Protocol. It also strengthens women's access to justice and effective remedies, dedicated article on that, and also calls for legal, social, and economic measures to eliminate discrimination and violence against women. So these are just some of the innovations that you have in the Maputo Protocol that you didn't have in other instrument previously. We will deal with, if you need to have any additional information regarding the other relevant articles of the protocol, we will deal with that when we have the interactive session. But we'll now move on to implementation and monitoring. Who has responsibility for the implementation and monitoring of the Maputo Protocol? And how do we monitor implementation of the Maputo Protocol? Because I think this is very important. So to highlight the fact that the African Commission oversees implementation of Maputo Protocol as per Article 32 of the protocol. And we receive periodic state reports pursuant to Article 62 of the Charter and Article 26 of the protocol. Here, I think I will pause and just say a little bit more about the African Commission. The African Commission is established under the African Charter, and we have commissioners drawn from all over the continent. Each region of the continent has 2 commissioners, and each region has 2 commissioners, and 5 regions of the sub-regions of the continent, and we have a floating commissioner. The commission has its headquarters in the Gambia, as you can see the beautiful building there where the African Commission is housed. We carry out our work through ensuring that we hold states accountable through the mechanisms and instruments we have. You look at the charter, you have the communication procedure where women's rights violations can actually be brought to the attention of the commission, and we can actually deliberate on that and issue decisions on it and make recommendations to states. But of primary importance in terms of accountability is the periodic state reports, which is provided for in Article 62 of the Charter and Article 26 of the protocol. State reports are very important as they enable interactive dialogue between states and the commission. And it is through the state reporting procedure that we are able to look at the legal, constitutional, institutional, and policy framework at the national level to ensure that states are actually complying with their obligations under the Charter and the protocol. So it offers an opportunity to engage in interactive dialogue between the states and the commission. The commission will actually review the reports and make sure that specific recommendations are made, concluding observations are made, calling for improvement in the legal, legislative, and institutional framework at the national level. And what is important also is the fact that apart from the reports that are submitted by the states, NGOs are also encouraged. So we have a state reporting guidelines, and the states are obliged to comply with the state reporting guidelines. But we also have shadow reports from NGOs, which highlights gaps in state reports. So whenever we have states presenting the reports, the reports will be published in our websites. Our expectation that in the confines of the guidelines, shadow reports, that NGOs, national human rights institutions, and interested stakeholders will also do a shadow report to supplement the information that is provided by the state, so that when we engage in constructive dialogue with the state, we have the real figures, the real statistics, the real reality on the ground with regard to what the state obligations and responsibilities are, what the gaps are, and what kind of recommendations we can make in terms of holding the states accountable with regard to fulfillment of commitments. One of the things that the Special Rapporteur on the Rights of Women in Africa advocates for is universal ratification and effective implementation of the protocol. So normally when states present their reports, the report is divided into several parts. The first part will deal with the charter. The second part will deal with the information on the Maputo Protocol. And generally, when information on the Maputo Protocol is provided, it will be the Special Rapporteur on the Rights of Women that will take the lead in actually interrogating and engaging in dialogue with the state on matters relevant to the Maputo Protocol. And other mandate holders actually will deal with matters relating to other instruments. I think we are concerned here with the Maputo Protocol, but it may interest you to note that at the level of the African Commission, the way we carry out our work, we have mechanisms, like I said. My mechanism is the mechanism of Special Rapporteur on the Rights of Women. We have mechanisms dealing with economic and social rights. We have mechanisms dealing with human rights defenders. We have freedom of expression, conditions of detention, torture, imprisonment, several mechanisms, working groups on HIV and AIDS, and so many other mechanisms. So one of the Special Rapporteur is just one such mechanism that actually engages in dialogue and ensures promotion and protection of women's rights within the continent, within the ambit of the Maputo Protocol. So since I've been talking about the Special Rapporteur on the Rights of Women, let me just give you a little bit of information about the mechanism. It is one of the oldest mechanisms of the African Commission. It was established in 1998 in Banjul, the Gambia, where you have the headquarters of the commission. Remember, I did tell you that the idea of the conceptualization of the Maputo Protocol was conceived of in 1995. So you can see that prior to the establishment of the mechanism, civil society organization and the commission as a whole expressing concern and interest about the rights of women within the continent. But I think to crystallize that interest, the mechanism itself was established. And its establishment primarily improved the promotion and protection of women's rights on the continent. And it's in line with the Commission's firm commitment and determination to promote the rights of women and girls, combat discrimination and injustice against women and girls, which are prevalent on the continent. So it is in recognition of the prevalence of discrimination and injustice against women and girls that the Commission thought it necessary. And of course, as we are championing and channeling the adoption of a dedicated instrument, it was found necessary that a dedicated mechanism should be established to actually follow through in terms of the commitment to establish a dedicated instrument. So this will just give an idea of the mandate holders since its establishment. I think if I count, I'm the 7th mandate holder. So as I work towards the promotion and the protection of the rights of women within the continent under the umbrella of the African Commission, it is important to know that I'm standing on the shoulders of all these phenomenal and women who started the journey years back before I joined. So we have Honorable Julian Nelenga, Honorable Angelo Melo, Honorable Suata Maiga, Honorable Lucy Aswago, Honorable Zainab Sylvie, Honorable Maria Teresa Manuela, a colleague of mine who's still within the commission. The others have actually since transitioned on and finished their mandate. And today I am the mandate holder responsible for the promotion and the protection of the rights of women. And in particular, not only that, but also ensuring that states actually not only ratify, but actually implement. And our responsibility in terms of accountability and promotion and protection also is to monitor and to assist states to ensure compliance with commitments in the protocol. So this is the responsibility we have. Like I said, this just tells us the assist African governments in developing and implementing national policies to promote and protect women's rights in Africa. And how do we do that? We undertake promotion and fact-finding missions to AU member states, monitor the implementation of the African Charter and its protocol by state parties. We draft resolutions on the situation of women's rights in African countries and propose them to members of the African Commission for adoption. So we actually initiate resolutions, which actually we propose to our colleague commissioners for adoption. And I must say that we've always been very successful in reinforcing the fact that the commission is really very particular about women's rights and is always ready to support resolutions that may need to be adopted to address specific aspects relating to women's rights. We also conduct a conference on the situation of women in African countries, and we continue to establish guidelines, general comments, and recommendations to help member states in regard to their state reporting obligation on specific aspects or articles of the protocol. We continue to do that as we move on. So in terms of general comments and guidelines, I think if you just have access to the website of the Commission, you'll find that since the establishment of the mechanism, it's been instrumental in developing comments and guidelines, like I said, to help member states. All yet was helping member states. But of course, we must note that in these general comments and guidelines, we don't only address member states, recognizing the collective responsibility of women's rights, protection and promotion. We do make recommendations for member states, we make recommendations for national human rights institutions. We also make recommendations for civil society organizations. And I think the very first general comment that was developed by the African Commission emanated from the mechanism of the Special Rapporteur on the Rights of Women. And this general comment number 1 on Article 14(1)(d) and E on women's rights to be protected from HIV infection and informed of their and their partners' HIV status. Very revolutionary and instrumental general comment and guideline, which has been commended. We continue to commend to states in terms of adherence to the principles and standards set there. That is general comment number 1. The very first general comment. The second general comment also is general comment number 2 on Article 14(1) A, B, C, and F, and Article 14(2) A and C on women's sexual and reproductive rights. I think it should not be surprising to you that we had to develop general comments on Article 14, remembering the fact that I did indicate that this is one of the articles that have been reserved by most member states. So we need to unpack actually the article and say what it requires to ensure that we're able to guide member states adequately. And we continue to actually encourage member states that have entered reservation to lift those reservations. As we develop our framework in terms of lifting of reservations, we will interrogate and encourage, engage more with these relevant articles, unpack it better, and make sure that we're able to guide member states to ensure full compliance. Then we have general comment number 6 on Article 7(d) of the Ramatoulie Protocol on women's right to property during separation, divorce, or annulment of marriage. I did indicate that property rights of women is also one of the articles that are actually reserved by a lot of member states. So there was a need to actually develop a general comment to elaborate on what Article 7(d) requires and what is the minimum standard that states need to comply with. Then we have the joint general comment on child marriage. I think you should appreciate why we're making all these general comments. Bear in mind, I did mention that these are areas where reservations were entered. And this joint general comment on child marriage is an instrument that was developed together with the African Committee of Experts on the Rights and Welfare of the Child. African Committee of Experts on the Rights and Welfare of the Child is also one of the human rights regional mechanism together with the African Court. But I must say that we have a very good and close working relationship with the African Committee of Experts on the Rights and Welfare of the Child as we continue to work together on matters that actually provide what we call a continuum of violation from a child to a woman. So child marriage is such violation. The Joint General Comment on female genital mutilation is another violation that actually happens to both children and women. So we always collaborate in doing that. We have the guidelines for combating sexual violence and its consequences in Africa. And this is also guidelines we provide for member states to ensure prevention, protection, punishment, and full rehabilitation, taking a very comprehensive and integrated approach to combating sexual violence and its consequences within the continent. So these are instruments and knowledge products that we develop to help member states to ensure full compliance with their commitments and obligations on the specific aspects or instruments, provisions of the Maputo Protocol. And we use those in our advocacy as we engage with states to ensure that whatever they do. So even within the communication procedures, when states actually when we prepare our communication procedures against state, we make reference to these soft laws. Also, when states present their reports to the commission, we interrogate and we find out how well and what they're doing in terms of compliance with these instruments that we generate, because we don't just generate the instruments for the sake of it. They're supposed to be used. So one of the things we do is also to raise awareness at the national level, so that to ensure that lawyers, judges, when they litigate, they actually use the instruments of the African Commission. Otherwise, this instrument will just remain innovative on paper, and they wouldn't serve any purpose. So we continue to actually encourage states, members of the legal practitioners, members of the judiciary, as they adjudicate, as they litigate, to use these instruments, so that at least we're able to build the right jurisprudence for that will ensure that women at the national level actually benefit adequately from the protections that are guaranteed in the Maputo Protocol. So this is the essence of why we keep developing these soft laws. Within the context of the soft laws also, it's not only the general comments and the guidelines that we do. We also pass resolutions, specific resolutions on thematic issues relevant to women's rights. Sometimes they're country-specific resolutions, sometimes they're resolutions on a particular matter of interest and concern to women within the continent. So we have several resolutions, the resolution on the health and reproductive rights of women in Africa, where we actually focus attention on a particular issue and reinforce and highlight the challenge and the problem, and make sure that we make specific recommendations to state for compliance. We have the resolution on the right to a remedy and reparation for women and girls victims of sexual violence, all referencing relevant provisions of the Maputo Protocol. We have the resolution on the protection of the rights of indigenous women in Africa. You know, these are dealing with the intersectionality of rights. You know, we have women whose rights are being violated, but within the context of vulnerable women also, we engage with that and ensure that we address those and speak to the issues relevant to those. We have resolution on women's rights to land and productive resources, also speaking specifically on the resolution of the situation of women and children in armed conflict. I think the issue of resolution of women and children in armed conflict, I mean, it will be obvious why we will have that, because the African continent is now ravaged with a lot of civil wars, political unrest, and we know that whereas all citizens of the continent have their rights violated, but women's rights are disproportionately violated. So there was a need to make reference to the relevant articles of the Maputo Protocol and highlight and amplify the need to ensure that women and children in armed conflict, the situation is taken into consideration and special protection is offered to them. We have a resolution on measures to protect and promote the work of women human rights defenders. I think this is very important. Women human rights defenders also find themselves being subjected to all sorts of violations, and this is a matter of concern to us as a commission. So we raise concerns relating to women human rights defenders and making sure that their special needs and requirements are addressed and their special status is taken into consideration. We have another resolution that builds on the resolution. This was in 2021. It may interest you to note that I was sworn in as commissioner in 2021 at the 6th session in Dakar. And one of the things I reinforced when I was appointed as Special Rapporteur on the Rights of Women is to just reiterate the issue of resolution on violence against women during armed conflicts in Africa, building on that resolution with the situation of women and children in armed conflict. And this is what we have, and we also use that for advocacy as we carry out our work. We have several other resolutions, but I just highlighted a few, I mean, for your attention so that you know the kind of work we do. We have the resolution on the protection of women against digital violence in Africa, the emerging menace of digital violence. These are emerging forms of violations and how it affects women. And we actually focus attention on that and call on member states to ensure that the situation and plight of women who experience digital violence is taken into consideration. And as a follow-up to this resolution also, we have embarked on a study dealing with the issue of digital violence within the continent. One of the areas of concern, I didn't share the resolution also, litigating women's rights, is the fact that despite the fact that we are mindful of the fact that women's rights are being violated at the national context and continent-wide and globally, you find that at the level of the African Commission, the number of communications, these are the complaints that get to the Commission on women's rights violations are very minimal. So this is a matter of concern, and it reflects the fact that at the national level also, women are not being afforded the opportunity to claim their rights. So we want to actually see how we can do a very comprehensive study, which we're doing together with that is the three human rights mechanism, that is the Commission, the Court, and the Committee. We're doing a comprehensive study to find out what are the barriers, what are the challenges to litigating women's rights. Because in all these human rights mechanisms at the African context, you have to exhaust local remedies. And if you don't exhaust local remedies, you cannot come to the Commission. So we have to encourage women at the national level to claim their right and to move away from the deeply entrenched culture of patriarchy, culture of silence that prevents them from claiming their rights and, of course, by necessary implication, being able to access the regional mechanisms for the protection and promotion of the rights of women within the continent. Otherwise, all these instruments we have, all the mechanisms we have will just be there, and the women will not be able to have access to those. So we're doing our best to ensure that we promote litigating women's rights together with our partners at the national level and ultimately the regional mechanisms. Okay. Now we move on. We've talked about the context, the background, and the journey of the instrument that is the Maputo Protocol. We talked about the innovative provisions. We talked about implementation and what we're required to do. What are the challenges and the gaps, ultimately? One of them is limited ratification by member states. And this, of course, delays full continental application. We would like this Maputo Protocol to apply to every woman and girl within the continent, not only in some countries, but all over the continent. So we're working towards universal ratification and as opposed to the limited ratification. So this is the aspiration of the mechanism of special rapporteur on the rights of women. The reservation on key provisions also is an area of challenge, and it undermines full implementation. Because if you actually say the Maputo Protocol is actually commendable, and we are commending the Maputo Protocol because of certain articles, and then those articles are the articles that are reserved, then it undermines actually the whole usefulness of the Maputo Protocol. So we want to make sure that reservations are lifted. Because like I said at the very beginning, entering a reservation is a commitment a member states make. Yes, we like this instrument, we're going to ratify it, but we're not yet ready for these articles. So it calls upon member states actually to take steps. So now what we're trying to do is to interrogate, are steps being taken, or are we just resting on our laurels? We don't want that. So this is something that we actually working on, and it's an area of challenge for us, the African Commission on People's Rights, and stakeholders, especially the rapporteur, especially rapporteur on the rights of women at the, in Africa, the African Commission. Another area of challenge with regard to the Maputo Protocol, yes, is the ratification is being done, but alignment of the protocol's obligation with national laws. For example, a fundamental area is criminalization of marital rape. You find that most jurisdictions, only a few jurisdictions actually are fully aligned with that. Of course, we had the political will at the level of the member states of the African Union to adopt a very progressive, transformative, and innovative instrument, but at the national level, ensuring that progressive measures are put in place to ensure gender equality within the national context also remains a challenge. So just getting the right political will to ensure that these commitments are fully implemented remains a problem. Of course, this instrument are sitting on cultural norms and religious beliefs, which continue to justify harmful practices as FGM and early marriage, despite the general comments, guidelines, resolutions, and instruments that we've actually developed on them. So recognizing the multi-sectoral approach that as we advocate, we use the law, we use traditional leaders, we use religious leaders, we use the opinion leaders at the national level to be able to promote compliance with this instrument that touch on aspects that are relating to cultural norms and religious beliefs. Because when it comes to norms and beliefs, it's like conviction. And I keep saying when I engage in convening, I said law reform is a process and change is not easy, but we will not relent and we will not give in. So what we want to do now is to work with progressive religious leaders, progressive traditional leaders, and use the tradition, the culture, and the scriptures themselves to promote women's rights, because it's a matter of interpretation. And we've had very progressive religious leaders who've actually interpreted it very well, and confirmed to us that even some of the prescriptions and provisions we have the Maputo Protocol are fully aligned with some of the religious beliefs. So we have to debunk the myth in terms of also the cultural norms and religious. It's more of myth than reality. And of course, advocacy, especially in rural areas, remain because it's one thing to have a very good and progressive instrument, but it's another thing to ensure that this instrument is popularized and women within the continent are aware of it and know about it. And this is an area where we need to work on, and with full admission that this is an area that we need to continue working on as we carry out our advocacy. It's not unusual. We talk about Maputo Protocol in some areas, and then women say, we don't know what this protocol is all about. So these are some of the challenges that we have in terms of the Maputo Protocol awareness and advocacy, and we continue to engage in sustained advocacy and awareness raising as we move along in carrying out our work. Yes, and another area in terms of the challenges I talked about dissemination at the national level. But then finally, I think it's important to note the limited capacity of gender machineries, because at the national level, we interact and interface with gender machineries to ensure implementation at the national level. Because what we do as mechanism holders is not to supplant and replace what happens at the national level, but to help enhance and collaborate and work together to ensure that the right mechanisms are in place at the national level. But you find that the problem we have is that when you look at the national budget, as we said, the national cake, you have the limited capacity, limited resources in terms of coordination and monitoring implementation of the protocols. We continue to see that remains a problem for us. Lack of data also hinders the tracking on progress on women's rights protection. I think it is important not only to have capacity, to have adequate funding, but also to make sure that we advocate evidence-based advocacy. We have the data that we're able to use to advocate when we deal with women's rights issues. And minimal involvement in civil society and in state reporting and monitoring processes. We continue to encourage the states to ensure that all stakeholders participate and take part. In fact, our guidelines are very specific that country reports cannot be presented, and we would not like to engage with country reports that have not been consultative and ensuring that all stakeholders. But sometimes you find that there's always somewhat minimal involvement. In fact, that's why we found it necessary to have our shadow reports, and we continue to encourage civil society to engage with that, so that at least if we do not have the full picture, in fact, we have the alternative, as we say, which we will actually take into consideration, at least engage in constructive dialogue, because the whole idea is to engage in constructive dialogue with the full picture being presented to us. But finally, I think today, what is very evident, not only in Africa, but globally, is the backlash against the feminist movement, the shrinking civil space. I mean, we're facing restrictions on legal restrictions, harassment, violence, limitation of resources, cutting of resources that I mean, just like the lifeline that we need to promote women's rights is actually being taken off. And this is some of the challenges, one of the biggest challenges we are confronted with. But we would not give up because, as I always say, the challenges we are facing today are no different from the challenges that the founding mothers of the women's rights movement had to be confronted with. Because you find that, as I keep to say, the founding mothers of the women's rights movement had to deal with colonialism, racism, deeply entering patriarchy, and we've moved on. And that context is no less challenge that in context we find ourselves. We're very resilient, and we will not give up, and we continue to use the instruments and the laws and the policies and ensuring the multi-sectoral approach to ensure that the rights of women are actually respected and that women are given their due rights. I think it's not a question of, it's an imperative that we cannot actually move on in society without ensuring that society as a whole, men, women, boys and girls are actually being able to be given the opportunity to participate and realize their full potential in all aspects, and ensuring their protection of rights, ensuring the prevention of violations, ensuring that the situation of vulnerable women, vulnerable groups, marginalized women, women with disabilities, I mean, women who find themselves in different contexts, indigenous women, I mean, women in distress, the elderly women, the intersectionalities as a whole are taken into consideration. Women human rights defenders, I mean, across the spectrum, actually have their rights protected and guaranteed. So these are some of the things, and we will continue. And that leads us to the issue of the recommendation. We're calling for universal ratification. We're calling for reform of observation. We're calling for prioritization of women's rights national agendas and allocation of necessary resources. We're calling for national laws and policies to be fully aligned, just like, just dealing with the challenges that we have. Calling for timely presentation of periodic report. We continue to engage in public campaign or education programs to inform citizens, especially women, of their rights. NGOs and women should be included in implementation report and monitoring process. So really, the recommendations are just responding to the challenges that we have with regard to the protection of the rights of women. I thank you very much. I don't want to take all the time. I keep looking at my watch, and I believe that you may want to have some time to interact I now offer you the opportunity so that we can have some interaction.
That was an amazing, powerful, such an informative lecture covering everything from the early days, the background to the current challenges. This question is from Rwanda. What are the main challenges courts face in enforcing the rights guaranteed under the Maputo Protocol, especially in cases involving reproductive rights, inheritance, or harmful traditional practices?
Okay, very good question, because like I said, these are the areas where we have challenges. And these are the areas that the Maputo protocols sought to address by having specific dedicated provision, imposing obligation on states to ensure realization of these rights relating to reproductive health rights, inheritance, and harmful traditional practices. And in my presentation earlier, I did mention that the Maputo Protocol is sitting on cultural, in a socio-cultural context where the beliefs, or should I say the myth, is that the provisions you have in the Maputo Protocol are not aligned with cultural values and socio-cultural values. But courts have an obligation, because once an instrument is ratified by a state, it's domesticated by the state, and it's provided for in the laws. Courts should, to answer your questions, courts should not face any impediment. Courts should be able to deliberate based on what the law says and enter judgment based on what the law says, and ensure that the rights of women are protected and upheld. Making use of the Maputo Protocol, because in some jurisdictions, we have the monist jurisdiction and the dualist jurisdiction. In some jurisdictions, as we know, as lawyers, those of you who are lawyers, once that instrument is ratified, it becomes part of the body of laws. In some jurisdictions, you have to go the next step to ensure that the law is incorporated. So the only impediment that the courts will face if the law itself, the treaty itself, is not incorporated in the national law. So, but where the treaty is actually incorporated in the national law, I don't see any impediment, especially if you are from a humanist jurisdiction. Also, where the law, for example, the example of Rwanda, I think there are specific laws that actually provide for this. I think the court should be able to use those laws. And I think what I would like to say and encourage, will encourage lawyers and judges within the national settings to continue to use our soft laws, because they help to elaborate on what the requirements of the law is, what the state obligation is. So we would like to see the not only domestication of the Maputo Protocol, but domestication of our instruments also by citing them at the national level. I use myself as an example. I think before I joined the African Commission, and this is where we actually want to continue to raise awareness, and so that people are aware of all this instrument. I litigate at the national level on women's rights issues. I had litigated a matter on equitable distribution of matrimonial property all the way to the Supreme Court in the Gambia. One of the ages of the Female Lawyers Association, when we were assisting a woman who found them being thrown out after spending years in the home, and the husband just says, "You have to leave. Are you a divorce?" And what actually this article provides is that equitable distribution of matrimonial property upon dissolution of marriage. But at the time I was litigating, and in the Gambia, we were fortunate that the Maputo Protocol was actually domesticated in our own legal instrument, so incorporated. But I was not privy to the soft laws of the commission. If I was privy to the soft laws of the commission, I would have been able to convince the judges more in terms of my litigation. So what I will want to do is, it's not about what the impediment is for lawyers, the judges, but what lawyers should do in presenting the case on behalf of their clients, and ensuring that they use the instrument, the Maputo Protocol, when they litigate, use the soft laws when they litigate, so that when the judges actually sit to deliberate, because these are persuasive authority. They may not be binding, but they're persuasive. So let's continue to use those to ensure that as we litigate women's rights, women are able to benefit from the Maputo Protocol and the soft law instruments developed by the Commission. I hope that answers the question. But of course, using the multi-sectoral approach, because I cannot leave this question by saying that I'm just coming from Nairobi on a promotion mission for the AU new instrument that has been adopted by the African Union, which is the AU Convention on Ending Violence Against Women and Girls, which we're also trying. It actually supplements and amplifies on the Article 5 of the Maputo Protocol dealing with violence against women and elaborating state responsibility as to what the states need to do. So if you look at the preamble, it references the Charter and the Maputo Protocol, meaning that it's building on the Maputo Protocol. And in my interaction with civil society, something came up which I would like to share with you, with the fact that in the courts in Kenya, a judicial decision was issued that there is nothing like an illegitimate child. Every child is entitled to inherit, because that is what the law says, and that is what the judges followed. But what has been the repercussions, the implications of that? So those decisions, implementation of those decisions, in reality, is becoming problematic, they said, because religious leaders are up in arms to say this is against our faith. How can you do a judgment that is against our faith? And they're actually now trying to lobby for a law to be enacted to sort of, because, you know, in the issue of precedents in terms of laws, you have the judicial decisions, you have the statutory authority, you have the constitutional authority. So they're trying to prepare a bill that would actually override the judicial decision. Of course, we're still encouraged by the fact that the Kenyan constitution, I told them, is one of the most progressive constitution when it comes to women's rights protection. And any law that doesn't ensure that consistency with the constitution will be declared null and void. So unless the constitution itself is amended, I don't see how that can succeed, because I have had the opportunity to look at the Kenyan constitution. It's one of the most progressive when it comes to women's rights protection. So I think I've answered and given you even more case study in terms of what is happening, because I just came fresh from Nairobi, and that information, I got it. And it may interest you to know that in the Gambia also, it was an attempt to enforce the law prohibiting female genital mutilation that led to the whole FGM debate and debacle in the Gambia, where the National Assembly members were actually seeking to repeal the law criminalizing FGM. And when that didn't succeed, they're now approaching the Supreme Court to say that that law actually is against religion and culture. So we're waiting to get that decision. So I think there are it's a multifaceted challenges that these instruments have in terms of implementation. It's not only about one person, but then again, we continue to encourage strategic litigation, because one litigation actually cannot be only for one woman, but actually would set a precedent that will apply to all other women. And this is what we try to encourage throughout. Thank you.
Thank you, Madam Commissioner. Your last comment answered a question that was in my mind. Yes, it may be very difficult to bring these cases. Yes, there may be no guarantee of success, but unless people begin to bring these cases, the women will not reach you and you will not be able to help them. So I hope that there are many courageous advocates for women who will be ready to take their cases to court. For some time now, some scholars from all over the continent have criticized the Maputo Protocol for importing Western culture or traditions. Then how can we reconcile women's rights found in the Maputo Protocol with African traditions, which is again related to the previous questions?
Yes. I think during my presentation, I did indicate that one major difference between the Maputo Protocol and the Charter is the Charter just makes reference to African values and traditions. But in the Maputo Protocol, the issue of African values, you know, you have a provision in Maputo Protocol, I should say from the onset, that talks about positive cultural context. So the Maputo Protocol is not against the culture, African culture. It actually encourages and promotes positive cultural context. But the cultural values of Africa and is actually recognized in the protocol, but linked to the issue of equality and non-discrimination, which are fundamental. I think this is something that we have to bear in mind. And I did indicate that, yes, there is a perception, that some of the provisions in the Maputo Protocol are against our cultural values. So sometimes culture is mixed with religion. You know, we don't know where one stops and where one ends, starts, and where what ends. But you find that when you really sit together with, I said, progressive religious leaders, and you share the relevant provisions of the Maputo Protocol, you find that they will tell you that what you have in the protocol is not different from African values. Because remember, this protocol it's not imported and just imposed on us. I gave it the journey, the conceptualization of the Maputo protocol. And throughout this journey, there is nowhere that is mentioned that an external stakeholder or somebody from elsewhere actually influenced. I talked about civil society, women in law and development in Africa, NGO, Forum of the African Commission. I talked about the African Commission, Made Up of Africans. So the entire journey I highlighted, I traced for you, actually debunks the myth that this protocol is from outside. The protocol talks about women in distress. We all know the challenges that women find with it. The protocol talks about widows' rights, talks about sustainable development, talks about harmful traditional practices that are detrimental to the health of women, talks about the challenges of early marriage and forced marriage. So these are things. In fact, I find it that it is a little bit insulting to say that all the innovations in the Maputo Protocol are there because it's external to us. I think this is not external to domestic violence, violence against women. The fact that it's so serious that I think the president of South Africa called it the pandemic within the continent because of the seriousness of the issue of violence against women. These are the lived realities of women within the continent, not anybody from outside. I think it's very clear. So what the approach, I mean, I always take when it comes to the proponents, that people who will say that this is against our values, is to actually get leaders from that context to come and talk to us about it. So that at least it's not only the special rapporteur of the rights of women who's talking to you about women's rights issues. You can have a religious leader, a traditional leader speaking on the issue and tell you that this is not religion, this is not tradition. This is about rights of women. This is about the welfare and well-being of society as a whole. I think this is the approach I would take. So the multi-sectoral approach actually always works. It's not one size fits all, because as we advocate, we must realize that different contexts require different approaches in solving problems. But taking the intersectional approach also works. Like somebody said, you go to the rural communities, they don't have food to eat, they don't have shelter, they don't have clean water. So, but when you approach this from the rights-based approach, you talk to them about the right, socioeconomic right, that this is the right they have. It's not a development issue. So linking the rights, so sexual and reproductive rights. So you don't just go, and I tell NGOs also, when you go into the communities, actually use the intersectional approach. Just don't go and talk about one issue, because a woman's right is not a one issue, with the theme issue. Talk about the intersectionality of right, everything else, interconnectedness of the rights. The fact that you don't have water, the fact that you don't have a housing, these are all violations of rights. And the state has an obligation. So this is the approach that may work and should work when we actually take the intersectional approach towards the promotion and protection of the rights of women. And I continue encouraging civil society organizations to do that.
Thank you. The next question. The African Charter on Human and People's Rights is fairly well known. The question is, what about education on the Maputo Protocol, which is not as widespread?
Yeah. I think the African Charter is well known, but the Maputo Protocol is not known. I think I did mention a challenge. Popularization is a challenge. I own up to that challenge, and we continue to ensure that we popularize it. But I think increasingly people are getting to know the challenge. And once you identify a challenge that is halfway to solving the problem, then you make sure you put in place strategies to solve the problem. And this is something that is on our radar, on our plate, to ensure that we popularize the Maputo Protocol, yes. In all, and that's why we continually insist that it's not just enough to ratify at the international level or regional level. It must be brought down to the national level, and national machineries at the national level should be able to use the Maputo Protocol to raise awareness, for the promotion and protection of rights of women. National human rights institutions also have a responsibility, because national human rights institutions do the work we do at the regional level, at the national level, because national human rights institutions are for the promotion and protection of human rights, and women's rights are part of human rights. So we continue to call on them also as they carry out their work to ensure that actually they use the Maputo Protocol and all other relevant instruments as they carry out their work at the national level and hold the state to account also. Yeah.
Well, I would be delighted to organize another lecture with you. We can talk about that later to continue to address these issues. The next question for you, please. In what ways can civil society organizations more effectively hold African states accountable for their commitments under the protocol, especially in countries where enforcement is weak or political will is lacking?
Yeah. Thank you very much. I think, like I said at the very beginning, promotion and protection is a collective responsibility. It cannot be done by the African Commission alone. We have 11 commissioners. The continent is huge and vast. And 11 commissioners, we're all not full-time commissioners, actually. We're all, as I'm talking to you, I'm sitting in my office. I finish my session, virtual session online, and I jump onto things. So it's impossible for me to know everything that is happening within the continent. And we work very closely with civil society, as I indicated. African Commission is one of the organs of the AU that has a very close connection on the with civil society. So we encourage civil society to take part in the NGO forum of the African Commission. We also encourage civil society members to actually apply for observer status, so that at least when you have observer status, you're able to speak, you have a right of audience on the floor of the commission to speak on the human rights situation in your context, in your country or in the continent as a whole. So this is what we encourage civil society members to do. How do you apply for observer status? Just go on the website of the African Commission and you'll find the link on observer status. It will give you all the conditions that you need to fulfill to become granted observer status within the African Commission. And if you are aware of information that is something that is pertinent based on evidence and concrete data, gross and massive human rights violation at your national context or in your environment, we're always happy for you to share that information with us. And this is where we generate our press statements, our urgent letters of appeal, and our resolutions to ensure that we speak to issues that are of concern to the continent or the national context. So we rely on and we work closely with civil society, but it has to be credible information. We cannot rely on speculation or AI generated, because now we're talking about technology and with the metaverse, AI generated information. So I think this is what we can do. I hope that has answered the question.
Perhaps I could ask you for some clarification. Let's say that there is a participant who is listening to you today and who is aware of a serious problem in his or her country. How exactly would they communicate this to you? And perhaps equally important, the information, yes, it has to be credible. Can this be done anonymously? Is there protection for someone who brings this to your attention? So I think this is a very important opportunity, but I'm not sure participants know how to do this.
I think if you go to the website, you get the address, the email address of the commission. And if once the information gets to the secretariat of the commission, it will be channeled, it will be handed over to the mechanism holder. If it's on women's rights, the legal officer responsible for legal officers supporting the mandate will actually bring it to our attention. And we never reveal, we never say, we just talk about sources. Once it's credible, it's not based on just media speculation. We will interrogate, verify, and we will engage. So we will write letters of urgent appeal to the heads of state. Sometimes we take steps without even the citizens being aware of it, because when we write an urgent appeal, it's from the commission to the head of states. We may issue a press statement depending on the seriousness of the violation. Yes.
So any
and we might even adopt a resolution on the subject, depending on how massive, how prevalent it is. Yeah, then we can do a resolution on a particular subject or theme. So we have an open door policy, if I may say that, if I may say so. We have an open door policy. What we want to be assured, like I said, it has to be credible. And of course, beyond that also, when states are actually presenting their reports, you have to watch our website. I think that's the means of communication. Before every month before a session, we always publish and indicate which state is coming to present. And the report itself, the report of the state is actually published. It's always for public viewing, so everybody can see what is being presented and what additional information you may want to share with us. Mm-hmm.
Thank you for that clarification. We have a comment from a participant in Algeria who is suggesting that Algeria has lifted its reservation.
Oh, really?
I,
Okay, this is interesting information. On which article?
I don't know. This is
Okay, we'll take the information and we interrogate that. That's additional information that I may not have. Yeah. Mhm.
sounds
And
like
because normally, and if reservation has been lifted, so we even send letter of commendation because we don't only name and shame and call out states. Sometimes we do commend states also when they do something positive. So this is something that we would like to interrogate, and I will send this to the secretariat for inquiry to be done, and depending on how recent it was. So if it's recent, we can send a commendation. If it's a long time ago, but we will also, in my activity report, another thing I do also is during every public session, every commissioner, every thematic mandate holder prepares an activity report. And one of the things that we highlight in the report is the state of women's rights within the continent. And if we find that Algeria had done it, even if we do not send a letter to Algeria, we will note it that Algeria has since this date lifted reservation on this particular article. So I will definitely follow up on that lead, and then do the.
wonderful.
Yeah.
Madam Commissioner, do you have time for one more question, perhaps?
Yeah. Okay, better one.
One more? Okay. This is also about reservations. This is coming from a participant in Cameroon. Cameroon has a reservation on Article 14 of the Maputo Protocol. For how long can an article be reserved by a state? Is it for, so basically, I don't think reservations expire, but this is the question. How long will this, unfortunately, how long will this reservation by Cameroon to Article 14 of the protocol exist? Presumably until they withdraw.
Until they withdraw. That's why, because we realize that states are entering reservations and not doing much about it. That is why we are prioritizing that. A resolution was adopted at the last public session. You may, if you check the website, you see the resolution we adopted. And we are actually preparing a framework for the lifting of reservations. You know, this framework is just to help states. Because I said to you, based on the Vienna Convention on Law of Treaties, when you enter a reservation, you're just saying that we're not ready yet to comply with this particular provision, but there's an expectation that you do something to prepare you to be ready, raising awareness, education, you know, information on the, and this is like, must say that civil society has a role to play actually, because in the Gambia, at least where I am coming from, I'm aware of the fact that civil society was very active as soon as reservations were entered. Workshops, seminars, you know, a lot of activities, events were embarked upon. What I did say, it's not one size fits all. You know, as a special rapporteur on the rights of women, one thing I've learned is everything is context specific. The context in the Gambia may be different from the context in Cameroon, and the approaches you take actually may be different based on the context you use. But one approach I find works very well is using the multi-sectoral approach that brings on board all stakeholders in terms of advocacy. And by the way, when we talk about the backlash also, sometimes we need to embrace those who are against us also to see the narratives. What are they saying? So that we listen to them and be able to counter the narrative. So I find that most women's rights organizations, when we meet, we keep speaking to ourselves, but we must extend our heart across the divide and bring on board men, boys, and also not only that, women who may be conservative and may have a contrary view, because that way we're able to educate and make sure we have we are all at the same level. So we have to also learn to be more proactive and ensure that we reach out to the divide, or what seems to be the divide, because at the end of the day, we are all in the same boat. We want to make sure that all women and girls within the continent benefit from the protection of the Maputo Protocol, irrespective of their political affiliation, their beliefs, their tradition, their context. So we need to reach out to the other side and stop talking to ourselves effectively, yeah.
I think we should probably stop here. And I would just like to thank you and congratulate you for your incredible years, if not decades, of working on behalf of women and girls and their families. Thank you so much for your time. I apologize to the wonderful participants that we simply do not have time to answer all your questions. But I would be delighted to follow up on this important topic with a lecture at a later time. So thank you very much, Madam Commissioner.
It's been a pleasure and the opportunity, and also I was able to get feedback, which is very useful. recognizing that Algeria has repair reservations, which is not part of my database. So I will build up on that and follow up on that link. Thank you very much. And thank you for the opportunity. And thank you for the interactions. And for those participants that I couldn't answer your questions, I think the conversation can continue at another level, another forum. And I'm hoping that the global feedback that I gave will also speak to some of the issues that some participants would have loved to raise and didn't have the opportunity. Thank you very much. Yeah.